Most business owners believe an IRS audit becomes more dangerous when the government starts asking a ton of questions. But in employee retention credit cases, or ERC cases, the opposite can sometimes be true. If your ERC audit suddenly goes quiet, don't assume the government has lost interest in your case. Sometimes the most dangerous audits become the quietest ones. Because while the civil audit appears to slow down, a criminal tax investigation may be gaining steam in the background. Hi, I'm David W. Klasing. I'm a dual licensed tax attorney and CPA, and for more than 25 years now, my team and I have represented business owners facing IRS employment tax audits, civil fraud examinations, and IRS criminal investigation matters. To date, we currently have 23 offices in 11 states to serve you nationally and internationally. Today, I'm going to explain how an ERC audit can quietly evolve into a criminal tax investigation, the warning signs most taxpayers miss, and why timing is critical. Once the government focus shifts from eligibility for the credit to criminal tax intent, most ERC examinations begin as routine employment tax audits. The IRS is going to review your 941Xs, your payroll records, your gross receipts calculation, and any documentation supporting your eligibility. The examiner is simply trying to determine whether your business qualified for the credit. Many cases in there, you're looking at adjustments, repayment, interest, and civil penalties. But not every ERC audit stays civil. The most significant change doesn't happen when the IRS asks for more documents. It happens when the examiner asks whether the claim was knowingly false. Questions may arise about government shutdown orders, gross receipts calculation, employee counts, payroll records, communications with ERC promoters, or documents created after the claim was filed. At that point, the issue is no longer simply whether you qualify. The government may be evaluating whether the claim was an intentional fabrication. This is where many taxpayers misread the situation. They suddenly stop hearing from the examiner. Phone calls suddenly no longer return. Requests suddenly stop. The weeks and the months start to pass by. Many assume the audit is ending. Sometimes the exact opposite is happening. If the examiner identified firm indications of fraud, the matter will be reviewed internally before any further contact. That silence does not necessarily mean the danger has passed. Several warning signs demand immediate attention. The IRS begins requesting original records instead of summaries. They start issuing summonses to your banks, to your payroll companies, or ERC promoter or preparer. Questions shift from calculations to your knowledge and your intent, and who advised you to file the claim in the first place. Former employees or bookkeepers mention they've been contacted. Those developments often suggest the government is looking beyond the numbers and focusing on the story behind the numbers. Most business owners believe the company that prepared the ERC claim is in the best position to defend them during an audit. That assumption can be dangerous. The promoter's interests are now dramatically different from yours. They may be under criminal investigation themselves. They can wind up becoming government witness number one against you, or they could simply disappear. Your defense should never depend on someone whose conduct may be under scrutiny. The most obvious sign that your case has changed from an audit when you get a visit from the Criminal Investigation Division is special agents appear at your home, your business. Remain polite. Do not lie. Do not speculate. Do not attempt to explain your ERC position on the spot. Advise them that your attorney will reach out to them. One false statement to an IRS federal agent, that can create a separate criminal issue even if the original audit is still ongoing. The strongest ERC defenses are built before a criminal tax referral ever occurs. So, first of all, preserve records. Evaluate your eligibility honestly. We're going to come in and look at the promoter's role in your case, identify any potential badges of fraud, and we're going to determine whether the matter is going to remain civil or requires a criminal tax defense strategy. Waiting around for special agents to appear often means your options have become much more limited. If your business claimed the employee retention credit and you've received an audit notice, a disallowance letter, a summons, or you notice that your ERC audit has suddenly gone quiet, don't assume that your case is resolving itself. At the tax law offices of David W. Klasing, our dual licensed attorneys and CPAs evaluate ERC matters through both a civil and a criminal tax defense lens. We're going to analyze your Forms 941X, your payroll records, gross receipts calculations, your communications with your preparer or the promoters that are involved, government correspondence, and potential fraud indicators in your fact pattern. We're going to try and determine whether your matter can still be resolved through a civil examination or requires an immediate criminal tax defense strategy. Call 1-800-681-1295 or visit Klasing-Associates.com to schedule a confidential reduced rate initial consultation. Because in many ERC cases, the most dangerous warning sign isn't that the IRS is asking more questions. It's really that the questions have suddenly stopped.